So we are supposed to start at 10, but our VC has very important work, and because of that we have to delay a little bit. Anyway, we are going to start the new day with that two-day national workshop on the 4 important acts in India. I welcome you all, and I won't take much long. So I would like to request our member secretary, Internal Complaints Committee, to do some announcement before we start. Dr. Lalengmawia, please come here.
Respected Vice Chancellor, sir, Finance Officer, members of Internal Complaints Committee, and faculty members of Mizoram University, good morning to one and all. First of all, I would like to introduce the members of Internal Complaints Committee of Mizoram University. Whomever I called may stand in your seat. First, we have our presiding officer, Professor Zokai Tluangi. The members are Professor Diwakar Tiwari, Professor Lalne Zoe, and we have Ms. Lalfam Kimi, who is an advocate in the High Court, but unfortunately she could not make it today because of family problem. And I'm Dr. Lalengmawia Tochhawng, the member secretary for this committee. And regarding the attendance of today's program, I would like to request all the respective heads of departments to submit the attendances for our own respective departments to me after the program, or maybe before the program, before the end of the program. And we all know that today's program is a very important one. If ignorance of the law is no excuse, we should all remember that ignorance of the law is no excuse, and duty is cast on individuals themselves about the law, and to avoid, and we cannot avoid any illegal act. So I hope that today's program will bring some light to us in regarding the 4 important acts of India. Thank you.
Yes, today is university program. Accordingly, our register make an announcement notification. So the teaching faculties is we are more than 250. All the attendance will be recorded. Even the absentees also we are going to record it. That records we are going to send to the administration and to the IQAC. This is, I think we have to learn many things. We teacher. All right. So we all know that no one, we all are different. We all have some uniqueness in ourselves, and even 2 persons are not exactly same. That individual differences. Accordingly, we have that attitudinal differences also. And because of that, for one people it might be a hero, but for another people he might be a very most wanted person. Just for an example, that Osama bin Laden, he's a hero for some people, but for some other, he is most wanted. Like that, we all are different. And because of that, we have to have some kind of standard which we have to follow, so that we all can harmoniously living together. And for that only, we have so many rules, regulations, laws, and acts. And for that, and for which national Indian government also have Indian Constitution, and so many amendments they have made it. And today, we all are here together. This is according to the instruction of the Indian government. All the central government has to do this kind of workshop frequently, not only one, frequently. The awareness has to have by every person. So we, Mizoram university is the central government body. It is an agent of the central government, and because of that we have to do it. This is a mandatory, and because of that university also today we are going to have this very important workshop. We are going and we are having, so we are a big number, and because of that we divided into three sessions, a series of workshop, we call it that. And for that today, this morning is for the teacher. In the afternoon non-teachers will be coming, and tomorrow our student and guest lecturer, all of those tomorrow they will continue, and so that we hope everyone will come to awareness of that, all of those acts. So our main concern is that for the being the internal complaints committee, our main concern, our main focus is that the sexual harassment of women at workplace. And along with that, we are trying to do another one also, the Protection of Children from Sexual Offences Act, POCSO, and the Protection of Women from Domestic Violence, and one more, Immoral Traffic Act 1956, because today, right now, we don't have any written complaint with us, but we smell it. Something happened, so that all of us will be able to free from that, be as an assailant, as a victim. And for that, this kind of awareness has to reach everyone. In our constitution also rightly say that in the fundamental right, that 14 and 15, it gives us equality, all right? And that equality, we have to live with dignity, as mentioned under Article 21 of our Constitution, for which we all are gathered here. And we are very lucky to have our Vice Chancellor, Honorable Vice Chancellor. He is very, very active. We all know it, that during his short period of time, he has done a lot of work. And he just come back from the Delhi. There he had been there and doing all the important work for the university. So I think he set some important model for us. And today also we are supposed to be the full of this hall. So the being so-called teacher who are going to teach other people, we are only here, only the good people are here. Where are the other people? So they will know themselves. No? Those who are here in the respectives of our department, only the good ones are coming here. Who are those people? Where are they? We do not know. So they themselves will explain it that. So I hope so the administrative people will come to know what to do. Oh, all right. Okay. So along with this, we have selected for X. We thought that this is very important, as we have said that we smelled it something about something happened, no? And along with that, we have seen that in our campus, it everywhere, free tobacco. So we teachers have to free from all of those, and we have to set an example for our staff and our student. And for that, the Kotpa Act 203 also say that if anyone committed such kind of things, and the fine is up to 200. So we all have to aware again that, and let them know, our students also. This is, I would like to remind again. So we have, okay. Before nothing much ado, I will happily would like to request Honorable Vice Chancellor to say something about in this very auspicious occasion, because we teachers are very busy with our teaching workload and another related workload like our project, maybe some kind of supervising our student, maybe some kind of another additional responsibility. So like that, we are very busy. It's really difficult to have time to be together here. In this occasion, our Vice Chancellor might have to say so many things. So whatever he would like to say, he can share with us to open, especially to open this two-day workshop, and also another whatever he would like to say with us. So, okay, thank you. Thank you, everyone. Okay, sir.
Very nice to have all of you in this morning for a very important topic. There is, I do not know, there is a committee. I know every institution has women harassment committee, and women at workplace, how to deal with. There are internal committees, but this committee is quite different. Complaints committee, this thing, another, so many things putting together. When Dr. Juali came to me, she told something. She highlighted that we have some complaint. What complaint you have? No. There is a complaint committee, and we want to organize a workshop. Anyway, thank you very much to be here, and the organizers like Professor Jobi, Professor Joklai Kalangi, Professor Tiwari, Professor Vanlal Chuana, and Dr. Juali Central Library doing a lot of work for this particular committee. Well, the theme is very important, very sensitive. When we say women harassment, sexual harassment, child abuse, it does not sound well. It touches our heart. Nirbhaya Kand. The country cannot forgive. Nobody can forgive such a heinous crime. Every day we see in the newspaper, every day we see in the television, so much of social crimes that take place, not in India, but abroad also. But I can say that being a citizen of this country, this is so much in India and most of the Asian countries. There are Supreme Court rules, state government rules, central government rules. You will find so many acts, hundreds of acts, rules, laws, regulations. That is one side. The another side is human value, respecting human value, mankind, respecting women, modesty of a woman, childs. They are the future of this country. If child is misused, abused, so also boys and girls, men and women. So it's our duty. Rules will be always there, acts will be there, parliament, legislature, government, those things are there. As long as we don't change our human values, we can't change the society. Me as an individual, a group of people as a society or a community, the state as a whole, the nation as a whole, the individuals as a whole, unless we change ourselves, there is hardly any impact on. So how do we restrict it? Through laws, regulations, rules. As I said, everything is there, but in Indian context, we have so many rules, thousands of rules, but enforcement, implementation is very poor. I know about all campuses, all over India, all campuses, there are big signboards, tobacco free campus, smoking free campus, but you'll find, in front of the gate or everywhere these cigarettes and tobacco are available. And where are the rules, laws, enforcement, police and other things? It's not here. Wherever you go, any part of the country. So these things are very serious in nature. Government of India is also, last week when I was Delhi in the newspaper, that the government of India is going to ban all tobacco products. And it's very hard to implement. It sounds well, it only sounds well, but very hard to implement because those who are the people who are sponsoring government, they are the man of crores, like Ambani and Adani. So it's very difficult unless we change ourselves, we condemn this type of abuse, child abuse, and women harassment, women exploitation, respect to women. Sometimes it's very difficult when we grow older. It's sometimes we are very careful. If there is a woman sitting in my front or standing on front, I am very careful whether I should left side or right side or front. Or better not to look because it should not give any message that woman modesty is being. There should not be any other impression. So as I said, that respect to women, modesty of women, whether it is a small girl or a woman of elderly age, as far as possible, I can quote many people, those in their entire life, it has been a principle that the respect to women is supreme. So if we work and we practice such spirit in our soul, I think we can change the society. And even if whatever the governments do, but unless we change ourselves, we cannot change the society. With these words, thank you very much for giving me an opportunity to be here. I was not late, but the audience was late. But it went in the name of Vice Chancellor was late because yes, I have urgent work. More work is urgent work is going on in the campus. Today there is a big building, this disability center, the entire building. From today onwards, with a MOU signature today onwards, it will be going to be the property of Mizoram University. The whole campus, whole building, quarters, boys hostel, girls hostel, very nice canteen. Once I had I been visit to that particular place. From today onwards, it will be the property of Mizoram. That work and paperwork, MOU, people have come from Kolkata, and there will be a function in the afternoon, handing over, taking over. All these things are going on. Besides, many other activities are going on. And with these words, once again, thank you very much to be here and for such an wonderful program.
Thank you so much. Thank you so much. Okay, I would like to request Member Secretary Dr. Lalai Sangzwali to propose a vote of thanks.
Honorable Chief Guest, Professor Pravakar Rath, the Vice Chancellor of Mizoram University, respected Finance Officer, Professor Vandal Chona, Professor Zhou Kaitluangi, the Presiding Officer, Internal Complaints Committee, Mizoram University, who is also a member of a state and national Lok Adalat and the trained Supreme Court Conciliator, and deans of schools of studies, members of Internal Complaints Committee, the teaching community of Mizoram University, our most esteemed guests, ladies and gentlemen. It is my privilege to propose a vote of thanks on this occasion. I, on behalf of Internal Complaints Committee, extend a very hearty thanks to our Honorable Chief Guest, the Vice Chancellor of Mizoram University, for giving us his approval and gracing this function as the Chief Guest. And I also extend our thanks to the Registrar of Mizoram University, Professor Lal Nundanga, for his cooperation in organizing this workshop. And I would also like to take this opportunity to thank Mr. Michael Zothankuma, the High Court High Court Justice and Executive Chairman, and Mr. Lalengmawia, Executive Secretary of State Legal Services Authority, and Mizoram State Legal Services Authority for providing us the reading materials, and the resource persons who is a conciliator. Our resource person is Johny Lalengmawia Tochhawng, and he had been provided by Mizoram State Legal Services Authority for this particular function. And he is also a state and national level Lok Adalat member, and also supporting us for with their reading materials, which we will be providing to all the deans of schools. I request the deans of schools to collect the reading materials from the backstage after the program. I would also like to take this opportunity to place on record our heartfelt thanks to Mr. Johny Lalengmawia Tochhawng, advocate, for extending his support and consented to be the resource person in spite of his busy schedule. An event like this cannot happen overnight. We all know that. The wheel started rolling weeks ago, and I would like to thank the university administration, especially administration, GAD, academic section, and public relations cell for providing the required logistic support and guidance they have extended for the success of this workshop. And finally, I would like to thank all the teaching community who have gathered here today for giving us your valuable time and ensuring your presence in this workshop. And last but not the least, I thank all the committee members of Internal Complaints Committee, Mizoram University, for giving their precious time so that this particular workshop can come into place. And I would like to thank each and every one of you again. Thank you all.
Okay, thank you so much. Now we have finished our inauguration function, and the first session for the teachers. The chairman would be Professor Pravakar Rath. He will take over the chair. Thank you so much.
May I call on stage Mr. Johny Lalengmawia Tochhawng, our resource person for today, to come up on the stage.
Good morning to all. The esteemed, our today's speaker, Shri Johny Lalengmawia. He is the state and national counsellor of Lok Adalat. It's a very learned and nicely, able to speak about the topic what we have decided today to discuss. Honorable Finance Officer is here sitting with us. Of course, he is a Finance Officer, but at the same time is a faculty professor also. So the deans, the head of the departments, the teachers from the different academic departments. As we all know that this is divided into 2 days and divided among the teachers, then the non-teaching, and then the research scholars, guest faculties, and the students. We are trying to cover the entire fraternity of the Mizoram University, the awareness program related to the these Act. And I'm very happy to mention that the Act 2013, the related to the women harassment and at the workplace. 2015, if I remember that, this was mandated by the ministry, at that time the MHRD, and they decided that every organization should have the internal complaint committee. And that act is also with me, and right from the inception I will say that I was associated with this internal complaint committee. And we are very happy to mention that in Mizoram University we do not have many complaints. Very few complaints that we have received. It's not time to discuss about the complaints and all that. We are gathered here to discuss, to see, or to know about what the Act says and how best it can be implemented in such organizations. So I would like to mention that which the few complaints we received, and very amicably we have handled all those complaints and we have come to an end, except one complaint. So other than that, in recent time, we have not received any complaint from any corner. So doesn't mean that, so the awareness should not be done. So we have decided that some of the awareness program in terms of the workshop or in terms of the signboards and other things. So for that, our chairman, she is taking actively on this part, and with the support of the administration, we are trying to do whatever necessary required in this direction. So I'll not take that much of time. So I'll request the esteemed the speaker. So please take it.
Thank you, sir. And a very good morning to all the respected teaching faculties of MZU. I'm very glad to be here as a resource person today, but at the same time, it's not easy to make a presentation before the professors and teaching faculties. And every day, I made a submission before the Honorable High Court, before the different judges, and at the same time at the district court. I can handle my case. But today is different for me because it's very difficult to make a presentation. I have seen my teachers and all other teaching faculties. So today I'm going to share with you some of the relevant laws which we are supposed to know. And my presentation will be short, and I'll be highlighted only some important topics. And however, we will provide you a printed material, a hard copy, as well as the soft copies for the future reference, and that may include the recent Supreme Court ruling as well. So coming to the first topic. So my first topic will be the sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. And sexual harassment at workplace is a widespread. It is a fact that women around the world from different countries have faced a similar problem, which is the sexual harassment at their respective workplace. And there was a strong calling for a strong law in order to combat these illegal activities around the world. Now coming into the Indian context, we all know that in order to fight back some illegal activities, we need a strong law. We need some authority. Without having any authority, we cannot implement or we cannot put the criminals into the jail. I cannot put the criminals into the jail because I don't have any authority to do so. So we need some law, we need some act in order to combat this kind of illegal activities. But before inception of this law, there is no proper law in order to convict or in order to punish the criminals, those who are doing some illegal activities to the women. But the only sections which we are having is under Indian Penal Code 354 and 509. 354 talks about the modesty of women, and the punishment is up to 2 years imprisonment. This is what most of the, before inception of this act, we are booked under this 354 and 509 of the IPC, and many of the criminals are put into the jail and convicted accordingly. Now, we are having this law, but prior to this inception of this law, the women who are under the sexual harassment came to the police station to file a complaint and to go to the court themselves. This is what one of the problem we are facing. Now, under this law, things are easy, more easier, and under the ICC, then a woman, a aggrieved woman can file a complaint. And I think I may stress upon this particular act. I think this is the intention of the organizer to stress upon. The birthplace of this legislation can be traced back to one landmark judgment of the Supreme Court ruling in the case of Vishaka versus State of Rajasthan, which is in the year of 1997. And in this law, there was a background, or there was an interesting story for the birth of this legislation. In the year 1992, Bandwari Devi, who was a Dalit woman, was gang raped in front of his husband at the state of Rajasthan. And after the incident, she approached the police, and the police are also helpless, and went to the medical hospital nearby, and the doctor on duty also declined to attend her. And she went to the court, and the trial court also discharged all the accused person, saying that the trial court do not found any sufficient evidence to convict the accused persons. But at the same time, there was a big debate in the year 1992, and that was reflected in the newspaper, national newspaper, as well as a local newspaper. And that, not only that, but in the parliament also, there was a big debate, saying that there should be some law to combat that kind of problems. Here, sexual harassment at workplace is considered violation of women's right to equality, life and liberty. This is equality, life and liberty that has been under the fundamental rights of the citizens that was in the Constitution of India, and this is also basic structure of the Constitution of India, which cannot be amendable. With this idea, the legislature formulated the sexual harassment of women at workplace, prevention, prohibition, and redressal Act 2013. This act came into force from 9 December 2013, and the same was also fully implemented here in Mizoram under strict guidance till today. And in the context of Mizoram, we have some records. During the COVID-19 pandemic, a complaint of domestic violence or this kind of sexual harassment at workplace has been increased. And in the Mizoram Police crime record also, during that pandemic time, this complaint is also increased, and in the court as well, a complaint has also been increased. And sexual harassment, what is the sexual harassment all about? And it has been defined under Section 2N of the Act. Sexual harassment includes any one or more of the following unwelcome acts or behavior, whether directly or by implication, namely physical contact and advances, or a demand or request for sexual favor, and sexually colored remarks, or showing pornography or other offensive and derogatory pictures, cartoons, or any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. The interpretation is very important in this regard. When a woman lodged a complaint and saying that there was a non-verbal conduct of sexual nature happened to me, and this guy had make unwelcome physical activities through me or something like this. If there is a complaint regarding that, the burden of proof is on the man. We have to prove are innocent, saying that I do not have any intention, I do not have any knowledge regarding that, but that was not a reasonable excuse. So this act, this law is very dangerous law, and someone said that this is since it is a woman's laws, so a man has to be aware of this particular law. Sexual harassment is not only a woman's thing, something to joke about and something to be ignored. It is very serious criminal offense. So if somebody lodges a complaint against us, we have to prove our innocence. So it is very difficult. So that's why we say that it is a very dangerous offense, a criminal offense. For having the basic understanding of this act, we need to know the definition of who are or who is the aggrieved woman, what is the meaning of workplace, what is the meaning of sexual harassment. Aggrieved woman, as per Section 2A of this act, it says that a woman of any age, whether employed or not, or it should be including students in school and colleges and universities. Aggrieved woman can be a student also, maybe at any age. Maybe she may be below 14 or below 12, or she may be any age. So the aggrieved woman can include a working or a student engaged directly or indirectly in a contract, works, voluntary or co-workers, probationers, trainees, visitors, all of them are covered under the Section 2A of this Act. And workplace has been defined here in this provision. It covers organized and unorganized sectors, government organizations, private sectors, hospital, nursing homes, sports utilities, facilities, dwelling house, school, colleges, all of them are included under the definition of workplace. That has been clearly mentioned in that handbook which we have provided to you. Then workplace also extended to off-site office, like a meeting or works taking place outside the office. So we may have a meeting at somewhere, maybe at 8 miles or something like this, maybe at Izol Club and all, but that is also extended to the workplace. If something happened at the Izol Club when we have a meeting, and that can be punished under this act. And outbound trainees, outdoors adventures, team building activities, clients meeting, training sessions, travel for office purpose, etc. And for the prevention and protection of sexual harassment at workplace, there are two important questions which always arises. One is who is responsible and accountable for the prevention. And what is the role of workplace in prohibiting and how? Who is responsible? And the most responsible person is the employer. Employer responsibility is very much high in this under this act. Then employer definition is there. Employer definition we all know. I may skip this. And employee's responsibility is also there. That was provided in the hard copy. Internal complaint committee. We are having that internal complaint committee in this university. It may not be necessary to stress upon. And internal complaints committee shall consist of the following members. We are having the respected members. This also, I may skip this. And the functions also, they are function very well as already narrated by our chairman also. Then how to make a complaint? How to make a complaint is aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal complaints committee within a period of 3 months from the date of incident, and in case of series of incidents within a period of 3 months from the date of last incident. The time limit may be extended for another 3 months if the ICC is satisfied with the reasons for non-filing of the complaint. If a woman is unable to make a complaint in writing, the ICC has to provide assistance. And who can make a complaint? A woman herself, that is the aggrieved, the victim. In case of physical and mental incapacity, her relatives may also file a complaint before the ICC, and friends also, then special educator, qualified psychiatrist or psychologist, guardian under whom she is receiving care, any person who has information about incident with written consent of the above. Then contents of the complaint must be this: date, time, location, working relation, parties, name and address of the witness, if any, should be reflected in the complaint. And this is the submission which will be provided in the hard copy. And appeal provision. Let us say the ICC had made an order. So we are not happy with the order of the ICC. What needs to be done? So there is an appeal provision. In that appeal provision, we may approach the law court also. This is frequently happen in that regarding this RTI and any other things also. Sometimes we are also not happy with the information provided under the RTI. Then we usually approach the High Court by filing a writ petition under 226 of the Constitution of India. Likewise, if somebody is aggrieved with the decision of the ICC, it's not the end of the road, then they may approach the law court. And regarding that punishment, there is a punishment which under this law, number one is the monetary relief. Then monetary relief compensation may be awarded to the victim, to the aggrieved woman, and the amount should be determined by the ICC. That should not be arbitrary. That should be calculated according to the seriousness of the crime committed by the accused. And if the accused is in the service, if he may be working under the government or maybe under the this private sector and whatnot, and the service rules, it has to follow the provision of the service rules, and the punishment may be imposed. And when a case has been registered under the criminal complaint before the law court, as earlier I have mentioned that 354 and 509 is a relevant provision which usually invoke before the law court. And in this regard, I would like to stress upon is that awareness is must, because the punishment is very severe. Once we are in trouble, it's very difficult to come out from that, like a particular punishment. So we may be a government servant, we may be working under the private sector. Once we commit a crime, maybe without having any knowledge or without intention, the punishment does not alter. So it's very dangerous. So we deem to know this particular case. I think this is all about the sexual harassment of women at workplace. Now moving to the second one. Shall I continue second one? Oh, okay. So I've given 4 topics, then I may continue one by one. And the second one is Protection of Women from Domestic Violence Act. Protection of Women from Domestic Violence Act 2005. Protection of Women from Domestic Violence Act was introduced and came into force in 2005. It guarantees under Article 14, 15 and 21 of the Constitution of India. And the Protection of Women from Domestic Violence Act 2005 is an act which provides for more effective protection of rights of women who are victims of violence of any kind occurring within the family and for matters connected therewith. And what are the acts of domestic violence? Number 1 is beating, slapping, hitting, beating, kicking, punching, pushing, shoving, or causing bodily injury or pain in any other manner. That will come under the Domestic Violence Act. And sexual violence. Section 3 defines that forced intercourse, whether she's a married woman or not, she may be my wife, and forced intercourse is strictly prohibited. Force you to look at pornography or any other obscene pictures or materials. Any act of sexual nature to abuse, humiliate or degrade you, or which is otherwise violative of your dignity, or other unwelcome conduct of sexual nature, and child abuse, which has been defined under Section 3 of the Act. And verbal and emotional violence. This has been frequently happen in the context of Mizoram as well. There are so many cases we are handling before the law courts. Verbal and emotional violence, insult, and a woman comes that this guy is insulting me. Then she lodges a complaint, lots of problem. Then name calling, like maybe somebody, we have a particular name, and maybe this some unwelcome name is also there, and we should not call a woman in that unwelcome name. Accuse on character or conduct, insults for not having any male child. This also happen frequently. Sometimes saying that my wife is not able to bear a male child, only a woman. This is also a punishable offense. Insults for not bringing dowry, wailing and screaming, preventing you or the child in your custody from attending school, college, or any other educational institutions. And economic violence, not providing you money for maintaining you or your children, not providing food, shelter, medicine extra for you or your children, stopping you from carrying on your employment or disturbing you in carrying on your employment, not allowing you to take up an employment, taking away your salary, income, wages, etc., forcing you out of the house you live in, stopping you from using and accessing any part of the house, not allowing use of clothes, articles, or things of general household use, not paying rent if staying a rented accommodation, preventing you from taking up a job, forcing you to leave a job, preventing you or the child in your custody from leaving home, preventing you from meeting any person in normal course of events, forcing you to marry when you are not willing to, preventing you to marry a particular person of his or their choice, threat to commit suicide, any verbal and emotional abuse. And who is the victim? Every woman or a child who is or has been in a domestic relationship with the respondent of the domestic violence can take the help of PWDV Act 2005. Any person, perpetrator who is or has been in domestic relationship with the aggrieved person victim, and also the aggrieved wife or female may also file a complaint against a relative of the husband or the male partner. Under the this act, a victim can get the following relief protection, which is clearly defined under Section 18 of the this PWDV Act, which is frequently ordered by the court to the safety of a woman. Let's say a woman make a complaint before the law court saying that his husband is threatening or maybe trying to kill her. Then the court provide a protection and give a direction to the superintendent of police, and that woman has been protected by the police personnel. And residence order, right to reside. It may be that the house building is maybe registered in my name. It does not mean that I'm the sole owner of the house. Usually in this PWDV Act, a male or we can say that the head of the family is by the court order, we force him out from the house, and usually the woman was kept in the house for the proper care. That is a residence order, right to reside, and monetary reliefs order, custody order, compensation order, interim and ex parte order. And monetary reliefs order is frequently granted to the a woman. Let us say my wife may not be working, I may be a sole breadwinner of my family, but after marriage, whatever we purchase is called as the acquired properties. Maybe let us say I purchased a vehicle that was registered in my name, and that was from my own salary. It does not mean that it is the sole ownership belongs to me. It is acquired property. Let's say when we divorce also, the court will see that after marriage, what property you purchase. Then that will be divided among the woman and a man. This is what the monetary reliefs also includes in that. Then a case can be filed before the law court, as I said, that may be skipped. And how to file a complaint, this has been provided in the handbook. And penalty. For the breach of protection order by the respondents, imprisonment is also there, which may extend to 1 year with fine or may extend to 20,000 rupees. And for not discharging duty by the protection officer, imprisonment, which may extend to 1 year or with fine up to 20,000 rupees or both. Here in this penalty, there is no minimum prescribed period for the imprisonment. So the court usually give minimum imprisonment at this stage. After 1956, when the human rights came into play, the court usually awarded minimum punishment. When the minimum punishment is not prescribed and the court thinks fit and proper, it was awarded. That was the second one. Now coming to the POCSO Act. POCSO Act, when the POCSO Act was came into force, at that time, Rajnath Singh was the Home Minister. He sent a strong letter to each and every state chief minister, and Mizoram also received that letter from the Ministry of Home, and that was circulated to the each and every department, and the nodal department is the Mizoram State Legal Services Authority, and this POCSO Act is very severe. I'm also handling 2-3 cases of this POCSO Act, and my clients are also now serving 20 years of imprisonment. Now he's very old age, more than 80 years old. The court had convicted for 20 years. Then I believe that he may not be able to come out alive, because now he's 80, you can count it another 20, because this POCSO Act is very dangerous. And as I said, that in the POCSO Act also, whenever a complaint has been made and saying that this guy or this man had sexually assaulted to me, then we have to prove our innocent. It's very difficult to prove our innocent. Sometimes, and the law says that if there is no medical evidence also, it is presumed that a child may speak the truth. A child speak the truth. So the burden of proof is on the accused, so it's very difficult to came out from these offenses. So it has come to effect from 14 November 2012 along with the rules framed thereunder. And it is comprehensive law to provide for the protection of children below 18 years and from the offense of sexual assault, sexual harassment and pornography and penetrative sexual assault, and which has been defined here. And the punishment is very important, which shall not be less than 10 years but may extend to imprisonment for life and shall be liable to fine. Then penetrative sexual offense is committed by someone and the minimum punishment shall not be less than 10 years. So it may extend to life imprisonment also. And aggravated penetrative sexual assault is defined here, and the punishment says that it shall not be less than 20 years, which may extend to imprisonment for life, which shall means imprisonment for the remainder of the natural life of that person and shall be liable to fine or with death. There is no provision in, under this POCSO Act to shorten the period of imprisonment. In other cases, in murder case, let's say he may be convicted for 20 years, but the governor or maybe the president of India can shorten the length of imprisonment. But under this POCSO Act, if the court convicted that particular person for imprisonment for life, which means that imprisonment for remainder of natural life of that person. Then sexual assault, whoever with bad intention and sexual intent touch the private part of the child and which act involve physical contact without penetration, and the punishment has been prescribed not less than 3 years or maybe extend to 5 years with or without fine. And the act casts a legal duty upon the person. If any adult citizen who has knowledge that a child has been sexually abused fail to make a report, he shall be punished with 6 months imprisonment or a fine. Maybe in our neighbor, we found that a child has been sexually assaulted or sexually abused. If we do not make a complaint, knowingly that has been happened, and we may be punished with 6 months imprisonment or with a fine. In case when a person is in charge of a company or institution or by whatever name called fails to report in respect of a subordinate under his control, shall be imprisonment with imprisonment of 1 year or with fine. Maybe we may be the head of department or maybe what we call the head of institution. Whatever happened, then we have to report that particular things to the competent authority, failing which we may be punished with imprisonment of 1 year and with fine. The act provide in camera trial. In camera trial means at the time of trial before the law court, and a camera is there in order, like sometimes we have cross-examine a child. We should not abuse a child. We should not put difficult questions to the child. This is strictly prohibited. Then medical examination of the child should be conducted in the presence of the parents of the child and in case of a girl child by a woman doctor. That is regarding the POCSO Act. And the last is Immoral Trafficking Act. The Immoral Trafficking Prevention Act 1956. This act does not make prostitution illegal per se, but it makes keeping and using of premises as a brothel, living on the income earned by prostitution, pimping, soliciting, seducing a person for prostitution in custody or otherwise, and prostitution in public area, an offense punishable under the act. It means prostitution is done independently or voluntarily, then it would not constitute an offense. This is what the Immoral Trafficking Act says about. The legal status of the sex workers in India, this law is very vague on the prostitution itself. The primary law dealing with the status of sex worker is Immoral Trafficking Prevention Act 1956. According to this law, prostitutes can practice their trade privately but cannot legally solicit customers in public. Section 2B talks about the brothel includes a house, a room, conveyances, a place or a portion. Sexual exploitation or abuse for the gain of another person for the mutual gain of two or more prostitutes. And Section 3 talks about uh, keeping a brothel or allowing a place to be used as a brothel shall be punishable offense with imprisonment of 2 to 3 years along with fine amounting to 10 rupees. What the immoral trafficking talks about is that this prostitution itself voluntarily done by a woman is not prohibited. It's not a punishable offense, but somebody are using a woman for earning income. This is strictly prohibited. In order to convict one of the offense of keeping or maintaining a brothel, it has to be proved that the place in question was being used for the purpose of sexual exploitation and not merely sex work itself. Subsequent clause of Section 3 prohibits the use and allowing use of place or a section of any place as a brothel by any landlord, tenants, or lessee. Let us say I have a tenant, and my tenants are running a prostitute's business and all, and knowingly, if I know that if I do not stop that things, then I will be punishable under Section 3 of this Act. Then Section 7 of the Immoral Trafficking Prevention Act 1956 prohibits carrying out prostitution in a public place or in a vicinity of a public place. For instance, carrying out prostitution within 20 meters of the place of religious worship, a hotel or educational institution is illegal. And Section 7 again talks about not only a woman who commit the offense, but also a man whom she involves are punishable with an imprisonment which may extend to 3 months. However, the punishment changed to 7 to 10 years with fine if prostitution is committed within such specified area with a child or a minor. And the Supreme Court has talks about this prostitution and saying that the Supreme Court order set limits on police action regarding sex workers and put sex workers and their children at the rest of the people. Consensual adult sex work and mere presence of sex workers in a brothel would not warrant an arrest or police interference as per the Supreme Court order. That is all about the Immoral Trafficking Act, and I may end my presentation, and I may take time to our respected chairperson. Thank you so much.
Thank you, Sri Johny ji has presented nicely, and he covered all the four the acts. That's the Sexual Harassment of Women at Workplace Act 2013, the Protection of Women from Domestic Violence Act 2005, the Protection of Children from Sexual Offence 2012, and the Prevention of Immoral Trafficking Act 1956. Thank you, sir. Very nice presentation, and I hope that our audience they could follow what you talked about. You have highlighted, given with the examples. He has explained the things. Now the session is open for the discussion. So I think that Sri Johny ji may take few questions if from the audience, if they like to ask anything, they can ask. Please.
You were explaining something in 1992 as a background to it in Rajasthan. So could you complete that? Because in midway, I guess there is a technical presentation and you skipped that part.
Oh, thank you, sir. This is regarding the sexual harassment at workplace, and the background is that in the year 1992, Banwari Devi was a Dalit woman from the state of Rajasthan. She was gang raped in front of her husband, and after the incident, she rushed to the nearby hospital, and the doctor on duty declined a treatment because of the gangster who raped her. And after that, she went to the police station, and the police officers are also helpless. And she's a very brave woman, and she filed a complaint before the trial court by herself. And the trial court also discharged all the accused persons, saying that you don't have any sufficient evidence, you don't have any medical evidence, you don't have a good police report, and the trial court cannot take up your case. So the trial court had rejected his complaint. And in the meantime, there was a big debate in the national newspaper and the local newspaper, and that has been come up in the parliament also, and there is a big debate. But as usual, there is no solution. Politicians and maybe the people are, throwing a stone to each other. But there is a PIL which was filed by one NGO, and the Supreme Court interfered in this particular case, and the Supreme Court framed some guidelines and give a direction, a strong direction to the Union of India, central government, to formulate some laws. So this is the background of the sexual harassment of workplace. Yes, sir.
Thank you. I'm Dr. Lakshmi from Department of Clinical Psychology. I have heard your first presentation about 2013 Act. I just have one doubt in my mind that you presented that burden of proof lies with the second party. So do you think still it's relevant? Like, don't you think this law is putting too much pressure on the main colleagues, on the main people working in an organizational system, that any female colleague or anybody, due to any reason, like if she complains with regard to anything, then the second party has to prove himself like he is not involved. So the law demands that the burden of proof lies with the second party. Why can't the burden of proof lies with the first party? First question. And second, in the same line, we are having laws against women, domestic violence against women, harassment against women, etc., etc. Why can't we have law against men? Harassment against men at workplace by female colleagues, harassment against husband and in the domestic sector. Why can't the law of India, the Constitution of India, when it provides the right for freedom, we have constitutional rights of freedom. So everybody has the right to live peacefully. So why can't always the second part, the second gender, has to be the target? Why our law, legal system? I'm just asking you because you are practicing High Court. So why can't our legal system takes this into consideration and draft some committee or something like that? So my second opinion. Why can't we have a law demanding sexual harassment against men at workplace, maybe 2023?
Yes, sir. And the first question regarding the burden of proof, sir, the intention of the legislature is very clear. That has been seen in the parliament debate also. Whenever we have a doubt in the High Court for the interpretation of a statute, then we came into the debate of the parliament, what the parliamentarian had said so and what the minister had said so. This is the intention of the legislature, what we call in the law code. And in this regard, the law says that a woman, let us say that this sexual harassment is very, how to say, it's not a good word. Okay, one lady says that this person sexually harassed me or something like this, and the other people may look down that particular lady. So this is what the parliamentary debate had said so, and saying that if a woman make a complaint, then he deemed to be saying the truth. This is what the law says. And it's very dangerous. And in the last last month, I have won cases at the High Court. And I am also representing the accused, who is 56 years old. And the High Court gave me 3 days for the safeguard of men. But I do not found anywhere in the Supreme Court ruling or any other law. Then the High Court judge also says that it's very Mr. Johny, it's very dangerous for a male to to accuse of these particular things and all. So the court also says that maybe male empowerment is required at this stage.
Yeah,
don't know.
I think
Ha.
like
It's very dangerous,
as I
yes.
got you from what you have just said,
Ha.
like laws have been created as the perception we held in the community.
Very true, sir.
So we held this perception that the one gender is suppressed, right? They are not empowered.
Yes.
The time has changed. People have empowered, right? So to prevent the misuse of laws,
Very true. Very
in my opinion, the burden of proof must lies on the first party who is accusing the second party. As you may know that in other cases, the burden of proof lies with the complainant.
Very true. Very true.
So why not with this particular law? No, I mean, there's a lacuna in as my opinion. I think this needs to be rethink by
Yes,
the
yes.
complainant authority.
Um,
And second, of course, you said male needs empowerment now.
yes.
I think so. It's my personal perception.
Yes.
Thank you.
By and large, still women are affected, children are affected. Of course, rarely the people who are accused are, there are cases, instances where, the real incident has not happened. So this law is necessary, I feel, because ultimately, the children, women, elderly, scheduled caste, working class people, they are suffering a lot. Still, the case of Visakha, there are so many Visakhas. Visakhas really, she was powerful, she was courageous to bring this legislation. And I hope all the perpetrators of rape against her have punished. You should have told that, whether they were punished or not by Supreme Court. Because, danda, see, I am talking about, talking from the point of view of, danda is needed. Now, ultimately, danda is needed. Some people don't realize the thing. For them, danda only will teach.
Yes. Yeah, that's fine if some questions were there. So that's why we have taken. And as far as just 1 minute. And the question which he has asked, I would like to just clarify that the provisions of the, in the ICC as well as in this act has been given. If suppose somebody has wrongly, intimated or made a complaint, there are the provisions under the ICC act. So that can be, resolved on that. It's that the other party also will be given a fair chance to discuss or to represent them. So it is not the one way that any representation or any kind of this thing. The second the point which he has been raised, that is irrelevant at this moment, because today we are not discussing that particular component. So I would like to request the audience that which is not relevant to that, please do not discuss on that. You discuss whatever the provisions are there. Within that provision, we should have a discussion. That's why a better awareness will be there. This is my personal request. So if any more questions are there, yes, please. If no more question or the doubt is there from the audience, I will not say the question, but if no more doubt is there, so let us, on behalf of the ICC, Mizoram University, and on behalf of the Mizoram University, we would like to thank our honorable speaker, Sri Johny ji. Thank you very much, sir. And let us join with me to give a big applause. Thank you.